What do 616,000 DACA holders do now? On Friday, July 16th, 2021, Judge Andrew Hanen out of Texas determined that the Department of Homeland Security violated the Administrative Procedure Act in creating DACA. He vacated the 2012 memo that created DACA. This is no surprise. I had predicted that Andrew Hanen would do this months ago. Now, more problematic, Judge Andrew Hanen also held that DACA was not justified under the Department of Homeland Security's prosecutorial discretion. This part of his decision could be problematic. Now, Judge temporarily stayed the DACA protections for DACA holders, saying that there was a significant reliance on the program. The temporary stay is just so the Biden administration can engage in its notice and comment rulemaking under the Administrative Procedures Act to fix DACA. So what the judge really did is say, hey, substantively, DACA is no good. Procedurally, DACA is no good. Nobody new can file for DACA. However, those that already have it can renew it temporarily while the government fixes these procedural issues. What do we know about DACA holders? Well, nearly 1.5 million individuals living in households with a DACA recipient today. There are more than 250,000 U.S. children to DACA holders. DACA recipients pay $613.8 million in mortgage payments a year and $2.3 billion in rental payments each year. DACA recipients also pay $5.7 billion in federal taxes and $3.1 billion in state and local taxes. Where do the 616,000 DACA holders live today? Number one, California, with 188,420 DACA holders in California. Number two is Texas, with 109,090 DACA holders. Number three, way below, with 34,890 is Illinois. Then comes New York with 29,390, 25,500 live in Florida, 24,700 DACA holders live in Arizona, only 16,830 in New Jersey, and 14,910 in Colorado. So what does this decision mean for Dreamers? Well, Dreamers without DACA today, including the 81,000 pending applications with USCIS, will not receive DACA protection, and they will be subject to removal from the United States. So if you were in removal proceedings and you filed for DACA, and we're hoping that DACA would get you out of removal, you have a problem. However, you might still be able to apply for prosecutorial discretion from ICE. Speak to your attorney. Current DACA holders can keep their work authorization and protection from deportation. They can also renew them temporarily. The temporary situation is for current holders doesn't look all that positive long-term unless Congress passes legislation or the Biden administration is able to save the program through its notice and comment rulemaking authority. Now, what does that mean? I keep on referring to notice and comment rulemaking. Under the Administrative Procedures Act, an agency has to propose new rules by notice to the public. There has to be a period where people can submit their comments. Then they have to review those comments, and then they propose final rules. That's what it means by following the proper rulemaking procedure. Neither the creation of DACA nor the attempted elimination of DACA by the Trump administration followed this notice and comment rulemaking, and that's why it was challenged repeatedly across the country. So what's next? Will an appeal overturn the decision? Judge Hanen's decision will certainly be appealed to the U.S. Court of Appeals for the Fifth Circuit, and eventually to the U.S. Supreme Court. Now, Judge Hanen decided that DACA was illegal substantively and procedurally. The Fifth Circuit is the most conservative court in the country. It is unlikely to reverse the entire decision, likely on procedural grounds. Now, you may recall that in 2015, Judge Hanen eliminated DACA That was the deferred action for parents of Americans and lawful permanent residents, also on procedural grounds. Now, DAPA was an expansion of deferred action to another group of people. In this case, parents of U.S. citizens and lawful permanent residents. The Fifth Circuit did not overturn that decision either. Going to the Supreme Court, now that it is a 6-3 conservative court, is not likely to succeed on the procedural issues. When this Supreme Court allowed DACA to survive in December 2020, it did so largely by saying the Trump administration did not follow the proper procedure under the Administrative Procedures Act. And the court laid out what the Trump administration would need to do if it wanted to eliminate the program. But of course, it didn't do that. So how the program was initially created was not before the Supreme Court in 2020. This decision will put the issue of how DACA was created squarely before the court, arguing that it was not procedurally correct. Judge Hanen's decision was not only on procedure, it also placed limitations on the use of prosecutorial discretion, and for that reason alone, it should be appealed. But even if we're successful, so even if the government is successful on the substantive reason, the Fifth Circuit could still eliminate DACA under the procedural grounds, even if the substantive reasons are found lacking. The result could still be the same for DACA holders. So what happens next? Hanen's temporary stay vacating DACA is conditioned on the government using its notice and comment rulemaking authority under the Administrative Procedures Act. In March, Department of Homeland Security Secretary Alejandro Mayorkas announced that the agency would be using its notice and comment rulemaking authority to support DACA. This is expected sometime in August. The White House has reiterated that it will do so. But whatever DHS does, it will then be challenged and reviewed, likely by Judge Hanen. So when DHS exercises its rulemaking authority, it is not limited by the original DACA conditions. That means that DHS can change the requirements for DACA and bring it more up to date. When DACA was announced in June 15, 2012, it had a 5-year look-back period, meaning applicants had to be in the U.S. before June 15, 2007. But there is no limitation on DHS today to issue the same requirements for DACA that it did in 2012 or that it did even in 2015 with DAPA. It can be updated. Does it have to be a 5-year look-back period? But even if it is a 5-year look-back period, moving it from 2007 to 2016, 9 years, that means a lot more people can now qualify that couldn't before. Depending on how aggressive the Biden administration wants to be, they can revive DAPA under its notice and comment rulemaking authority. The risk of doing so and doing it successfully is that we might create a permanent class of people who are in this country but can never be citizens. The best way to protect DACA holders is for Congress to act and make DACA no longer necessary. Senators Dick Durbin, he's a Democrat of Illinois, and Lindsey Graham, a Republican of South Carolina, reintroduced the DREAM Act to provide DACA holders legal status and path to citizenship. In March, Democrats and some Republicans in the House of Representatives voted to pass the Dream and Promise Act, which would also provide legal status and a path to citizenship for DACA holders, TPS holders, temporary protective status, and DED holders, deferred enforced departure. What will happen? Well, in the next month, I anticipate DHS will propose some version of DACA for notice and comment. We will see how aggressive they go. It is my hope that that becomes unnecessary because Congress passes something to help this group of people. Thank you.